Muy buenos días a todos y a todas en las Américas y muy buenas tardes a quienes nos acompañan desde Europa. Vamos a continuar con el ciclo de conversatorios sobre las experiencias internacionales sobre negociación colectiva, condiciones de trabajo y productividad, que estamos organizando desde la Organización Internacional del Trabajo. Y permítanme agradecer a mi colega Catarina Braga, quien ha coordinado esta sesión de hoy y quien va a moderar. Y en ese sentido, déjenme pasarle la palabra a Catarina para que dé también la bienvenida, la introducción del caso de hoy y agradecerle nuevamente a mis colegas también de la oficina de OIT en Portugal, quienes han apoyado la realización de esta actividad. Catarina, todo tuyo el piso.
Muchas gracias. Pues soy Catarina Braga del Departamento de Condiciones de Trabajo e Igualdad en la sede de la OIT en Ginebra y trabajo en el marco de la negociación colectiva, en particular de los salarios. Pues este ciclo de conversatorios lo organiza la OIT Cono Sur, OIT Argentina, con el apoyo de mi departamento, en asociación con el Ministerio de Trabajo, Empleo y Seguridad Social de Argentina. Pues aprovecho para compartir también que la semana pasada la OIT ha publicado su informe sobre el diálogo social del 2022. Se trata de un informe bastante importante que en su primera edición se enfoca precisamente en la negociación colectiva y es parte de un esfuerzo de la organización para colocar el tema del diálogo social y la negociación colectiva como un tema crítico en el mundo laboral contemporáneo y también en el futuro del trabajo. Hoy, en este ciclo de conversatorios, discutiremos el caso de Portugal. Nos complace estar acompañados por Rosario Palma Ramalho, profesora catedrática de la Facultad de Derecho de Lisboa. Rosario Palma ha estudiado y escrito extensamente sobre negociación colectiva y relaciones industriales. Hoy compartirá con nosotros algunos aspectos del working paper que escribió para la OIT sobre las relaciones laborales en el contexto del programa de asistencia financiera que tuvo lugar en Portugal entre el 2011 y el 2014 con el FMI, la Comisión Europea y el Banco Central Europeo. Pues teniendo en cuenta el acuerdo reciente entre el FMI y las autoridades argentinas, nos ha parecido pertinente traer el caso de Portugal. Profesora Rosario también compartirá con nosotros su perspectiva respecto a una actualización de los contenidos de la negociación colectiva en el contexto nacional portugués, incluyendo dimensiones que se vinculan con la productividad. Pues en una primera parte, y tal como en el primer ciclo de conversatorios, tendremos una presentación abierta al público en general de aproximadamente 25-30 minutos, seguidos de una sesión de preguntas y respuestas con el público. La primera parte se transmitirá en línea y quedará disponible en el canal de videos de OIT. En la segunda parte tendremos una reunión técnica con una participación más restringida. Profesora Rosario hablará en inglés. A quienes están conectados por Zoom, me gustaría informar que hay interpretación simultánea inglés-español y que en el mundito que aparecerá abajo en la pantalla pueden elegir el idioma. Les pido a los que están conectados por Zoom que durante la presentación, la primera parte en YouTube, mantengan sus cámaras y micrófonos desconectados. Al público conectado por YouTube y escucharán siempre en español. Y por supuesto, me gustaría también pedir al público que dejen sus preguntas, las que serán respondidas al término de la presentación. Y pues, sin más, paso la palabra a la profesora Rosario Ramalho. Muchas gracias.
Muchas gracias a ti, Catarina. A mí me complace muchísimo de estar aquí con vosotros. Quería decir gracias a la OIT por invitarme a la OIT también en Argentina y decir buenas tardes a todos, buenas tardes aquí en Europa, buenos días a todos. Voy a hablar en inglés porque mi castellano es muy deficiente, por eso para una exposición técnica que voy a hablar en inglés. Y por eso también gracias a los intérpretes que voy a hablar despacio para que todo pueda comprender. Well, I would start by saying that I will divide my presentation into 3 parts according to what was required from me. The first one is to introduce the subject. It is important to make it possible to understand the Portuguese situation that we had and the measures that were adopting during the assistance program that was in place between 2011 and 2014. It's important to have some background. So I will give you a brief overview of the Portuguese labor law in relation to employment contracts and to industrial relations, and also a brief overview of industrial relations prior to this program of financial and economic assistance that we had here in Portugal. So this will be my first topic. My second topic is to briefly describe the measures implemented in Portugal under this financial assistance program that was implemented in Portugal by the IMF, the European Central Bank, and the European Commission. And thirdly, I would say something about the latest developments, the developments after the end of this program, and more and today, and what are the main trends in relation to collective bargaining today. So going into my first point, I would start by saying that Portuguese labor law relies mostly on legal provisions, but also on collective agreements. Those agreements are concluded between the employers' associations and the trade unions as representatives of the employees. The Portuguese constitution has a whole set of fundamental rights related to employment contract, but also to industrial relations. And this set of rights have influenced along the years the legal system, and the legal framework of employment contract has been for many years shaped over the model of the typical labor relation, which means industrial labor relation. And from the mid-1970s onwards, collective bargaining developed largely also on the basis of very traditional principles, such as favor laboratoris, interpreted in the most traditional way. In this regard, collective agreements were conceived as instruments that aimed only to improve legal provisions. Legal provisions were considered as the minimum standard of labor protections, and consequently, collective agreements tended to be more protective than the law, and also tended to remain in force for a long time. It's clear to see that as a result of these two trends that I have just spoken about, Portuguese labor law was placed among the more protective labor systems in Europe for many years. In European surveys, it is commonly said Portugal is placed among the systems that protect the most the employee. And this concerns not only the subject of internal flexibility, which had made his own way during the years, but maybe later than what happened in other countries, but also as regards the admission and the regulation of atypical forms of work in a tendency that is known, as you know, as external flexibility. Nevertheless, we can say that at the end of the 20th century and in the first decade of the 21st century, there was a significant evolution in the Portuguese legal sentences, and especially we had a labor code. Our first labor code was approved in 2003, and this labor code adopted new provisions regarding the relation between legal provisions and collective agreements, allowing, this is very important for our subject, allowing for collective agreements to establish less favorable conditions than the law. Also, this code for the first time established that collective agreements cannot stay in force forever. They have to be seen as a transactional agreement that where you must introduce some dynamics, and these dynamics must result in the replacement of an old agreement by a new one. And this is the general picture from 2003 onwards and until and for the first years. When you look, this is the general legal feature before the reform of 2011 and onwards. Also, if you look at industrial relations and social dialogue in Portugal prior to the crisis that we had in those years, you can highlight certain aspects. But the first one is that the great majority of Portuguese companies are very small companies, which mean less than 10 employees. More than 90% of the Portuguese companies are very small companies. Also, it is important to notice that Portugal has a long tradition of social dialogue between the government and both the representatives of employees and employers. This tradition can be traced back into the 80s, so it's really consolidated, it's really there. And this social dialogue allows for the discussion of pending legislative new acts, and everything is indeed discussed there. It's a new form of making the legislation. Tripartite agreements are regularly concluded between the government, the unions, and the employers' associations. And to a certain extent, these tripartite agreements that are regular in Portugal are the material basis of the changes that are later on introduced in the legislation. Also, there's a long tradition of collective bargaining and collective agreements. And the branch and professional level agreements are more common than the company plant level agreements. We have, therefore, a very centralized collective bargaining systems. Finally, it is important that the competence to celebrate collective agreements is recognized by the Constitution only to trade unions. There was an effort to extend this competence to also workers' councils, and until now, this had no practical effect. Finally, as to the content of collective agreements, in the last decade, they have developed more flexible provisions, especially as in relation to working time arrangements. But as regards remuneration and dismissal, for instance, the content of collective agreements is still rather rigid. It is also important to say that in Portugal, collective agreements are applied under a general rule, which is the affiliation principle. You are only subject to a collective agreement if you are a member of the union, of the trade union that has celebrated that agreement. This is a result of a constitutional provision. You cannot be subject to a collective agreement if you're not a member of the trade union that has signed that. However, quite regularly, collective agreements also apply to employees that are not a member of the trade union that has celebrated those agreements, because there is an administrative extension procedure that makes that is approved by the government, and that makes that collective agreement applicable to workers that are not unionized, or even to workers that are members of other trade union, if that trade union has not celebrated a collective agreement on its own. So this is called the portaria de extensão. It's difficult to say it in English, but the notion is, as I said, an administrative procedure that makes the one collective agreement that had been celebrated between a certain trade union and a certain employer or employees association, and makes it applicable to other workers that are not unionized. Of course, this administrative extension of collective agreements fills in the gap caused by the low level of union membership in Portugal. The number of workers that are unionized has fell down drastically. It was, when I wrote this report, it was situated below 30%, and now it is situated below 10%. The last numbers are really appalling. The great majority of employees are not unionized. They don't belong to any trade union. And so what is the collective agreement that should be applicable to them? The one that the administrative extension procedure indicates that is applicable to them. And what we have is really an unbalanced situation. You have a collective agreement that is applicable per se only to a small number of employees, and then that same collective agreement is applicable to all the others throughout this administrative extension procedure. And now presently we have almost 80%, it's always around 80% of all the workforce is covered by a collective agreement, while less than 10% belong to a union. So this is how the system works. Finally, I would have to say that the dynamics of collective bargaining and of collective agreement is poor, because collective agreements tend to stay in force for a long time. This was the situation prior to 2003. The Labor Code of 2003 tried to change the situation, but did not succeed. So this was the situation when Portugal had to go into the assistance program. So three main conclusions as regard the general features of the Portuguese system and of the Portuguese industrial relations before this crisis. The collective bargaining system was rather rigid. since it largely relied on top-level branch or professional agreements rather than plant-level agreements. The system is hampered by the limitations imposed by the law regarding the replacement of collective agreements. Thirdly, the Portuguese system of collective agreement is very efficient since it covers almost all the working force, but this high rate of coverage does not reflect the will of the workers, since only a few, a small percentage of these workers really are members of the trade unions. So the system risks to be not very representative, since it does not reflect the will of the workers. So this would be my first point. And it's important to have this overview so that I can explain the extent of the measures that were taken during the assistance program. These measures rely on a memorandum of understanding that was concluded in May 2011 between the Portuguese government, the International Monetary Fund, the European Commission, and European Central Bank. We call it the MOU, Memorandum of Understanding. However, I must say that some of the measures that were taken also relied on a tripartite agreement concluded between the social partners. Almost all of them, only one from representing workers did not sign this agreement, and this agreement had been signed in January 2011. So the program, the MOU, the Memorandum of Understanding, largely relied also on this tripartite agreement, and this shows how very important the social dialogue is indeed in Portugal. Many measures were established in this Memorandum of Understanding, and many were applied. Some related to employment protection legislation, others to employment benefits, others related to working time arrangements, others to wages, and some of them were directly linked, related to collective bargaining and social dialogue. I will focus my attention only in these latest ones because it is our subject here. As regards collective bargaining and social dialogue, the measures proposed and implemented were the following. It was established that the administrative extension procedure should not be free. It should be valid only if some clear and clear substantive criteria were present. So it would no longer be free, the minister, to extend all collective agreements that were published. And that was a practice before. So you had a collective agreement and there was immediately an administrative procedure for its extension. Also, another measure, very important measure, was intended to introduce more dynamic on collective agreements by the way of shortening the validity periods of those collective agreements. Collective agreements always have a deadline. I mean, for instance, 2 years, 1 year as regards wages, and 2 years. This is very common. But after those 2 years, we would say that the lifetime of a collective agreement would end. But what happens is that it stays on. It's still applicably like a zombie creature. So until the parties have the time to renegotiate. And what this is the rule that was established in the labor code of 2003, and that was kept in the labor code of 2009. And one of the measures that should be adopted is that this second period of the zombie life of collective agreements should be shorter than it was, so that the parties would have to negotiate faster and replace the collective agreement. If they didn't do it, the collective agreement at a certain time would end, no matter what. So, and then the parties would have to start all the negotiation process from the beginning in order to approve a new collective agreement. So a very important measure was the measure that intended to reduce the afterlife of collective agreement. Another very important measure that was put in place intended to promote decentralization of collective bargaining. Because until then, and still it's the same today, until then, professional and top-level collective agreements are the more common. So the law intended to promote social, the plant level agreements, and also to allow other entities aside trade unions to conclude collective agreements at plant level. It would be the competence of the workers' councils that would have to be recognized in companies with more than 150 employees. So the measures should be considered together, because they were all of them were going to the same goal. What happened in place was the following. How was this put in practice? First, there was a resolution approved by the government that really defined very clear and strict criteria allowing for the administrative extension of collective agreements. This was approved in 2012, and the practical result was that the level of coverage of collective agreement dropped instantly. So not anymore around 80% of the workers were covered, only 30% of the workers were covered. And this was a drastic result. As to the promotion of decentralized collective bargaining, this really was not put in place as it had been indicated in the memorandum, because this was allowed for the workers' councils, but under delegation of the trade unions, or in practice, trade unions never delegate in the workers' council. So the system was not changed. And another measure that was put in place was the creation of a labor relations center composed by all the social partners to monitor the content of collective agreements. So now this is a very practical measure, but it had a good result, because now we regularly have a publication every year that says the collective agreements are published were these ones, the content is this or that or that. So it is very easy to monitor. What happened after the crisis, and this is really my third point. I have to say this quite plainly. I am an academic, so really I can say really my view. I'm not a political person. From the year 2014, so after the program, I start by saying that some of the measures that had been put in place during the crisis were rapidly reversed. These reversions are related to the administrative extension of collective agreements, to unionism, to the predominant model of collective agreement, and to the dynamics of collective agreements, and finally to the content of collective agreements, of which you also want to know something about. As regards the administrative extension of collective agreement procedure, already in 2014, the Ministers' Council resolution from 2012 that had limited that procedure, the criteria allowing for that procedure, was changed, and was changed in a way to promote a little bit those extension procedures. And in 2007, a new resolution revoked the old and reinstated the ancient system. So what we have now, the practical result that we have now regarding the administrative extension of collective agreements, that is that almost all collective agreements are extended. They are extended by the will of the Minister of Labor. And as a result, almost all workers are covered again by collective agreements. So the system is efficient again. But of course, when you compare this data with unionism, there is a drop, even more, a big drop in unionism. The latest numbers indicate that less than 8%, not 88% of the workers belong to a union, and only 16% of the employers are members of an employer association. So there is no need to be a member of a trade union to be covered by a collective agreement. So collective agreement system is efficient since it applies widely, but it is not representative. As to the predominant model of collective agreement, before the crisis, the predominant model were top level and branch or professional collective agreements. During the crisis, plant level agreements raised a lot. They raised a lot. It was a very interesting thing to witness. But after 2014, with again the extension procedure, again, top level agreements became dominant. Now there's significantly, both types of agreements have they have the same use. As to the dynamics of collective agreement, this is a very difficult point. Because we had during the crisis an evolution in the sense of shortening the afterlife of collective agreements, what I call the zombie application of collective agreements. And in more recent years, this evolution was reversed. Collective agreements stay in force during the time that is established by the parties. This is the normal life, but they also stay in force in a sort of afterlife. And several pieces of legislation that were approved since those days tend as a whole, when considered as a whole, to make this afterlife of collective agreements more extensive and more extensive than it had been before. So this is really the situation was completely reversed. Also, there was a principle that really contributed, in my view, positively contributed to a more flexible content of collective agreements, which was the principle that stated in the Labor Code of 2003 that collective agreement should not be admissible only to establish more favorable conditions than those conditions that were already established in the law. They would also be admitted to establish less favorable conditions than those established in the law, except in specific areas. And those specific areas relate to personality rights, equality and non-discrimination, dismissal, or, well, really key areas. And what happens is that from time to time, these exceptional issues where collective agreements cannot be less favorable than the law, these exceptions are getting wider and wider and wider. So the flexibility in the content of collective agreements and their capacity to adapt themselves to not so an economic environment that is not so nice anymore is now lower than it was before. Finally, and I rest my case here, if you allow me for one more observation, Katarina, in relation to the content of collective agreements. The content of collective agreement can be what the parties wish. There's an absolute freedom to establish whatever the parties intend or want that to be treated. The Labor Relations Center that I have mentioned earlier, and that was created during the assistance program, regularly monitors the content of collective agreements, which means that we actually can see what issues are being dealt with on a certain year, what is not being dealt with in the next year. So it is very, very useful. Well, we also can see as a general rule that all collective agreements deal with wages, working time arrangements, specific employment contracts, etc. Mostly at plant level agreements. Other issues arrive, for instance, professional hazards, flexible working time arrangements, job evaluation, equality, health and safety, harassment practices. These issues tend to appear more at plant level collective agreements than at professional top level branch agreements. But indeed, they can well establish what they want and treat the issues that they wish. And their content is limited in those aspects, in those issues where the law still says this is the minimum standard. So you can only establish more favorable regulation. So I will come now to my closing remarks, just to say that today, in my view as an expert, and where industrial relations and collective bargaining is concerned, the Portuguese legal system still needs to implement some changes in order to become more representative. This is a big issue in my view. More dynamic. This is another issue, and more adaptable. I'm not sure if the Portuguese have learned a lot from the crisis. So the importance of being more representative is huge. You have to have a representative system. Otherwise, it lacks in legitimacy. It's not legitimate. And in a sense, the procedure the legislation that limited the administrative extension procedure regarding collective agreements tended to increment more to a more representative system, but it has failed in its objectives, and it has failed because the social partners did not agree with this measure. This is very important to say. Also, it is important to have an adaptable collective agreement system, because collective agreements should have the ability to adapt to not so nice economical environmental situation, even if it means that for a certain period the wages go down, for instance, as in order to keep the jobs. So this is possible theoretically, but it's not done in practice. And if collective agreements stay in force longer and longer, not in their normal life, but in their afterlife. The system is not adaptable. And still, because there is another rule that is still in force, that a new collective agreement that replaces an old one should be more favorable than the old one. This rule is still there. It has never been revoked. I would say it should not be justifiable today. So this would be my remarks. I hope that I have covered all the issues that the ILO has asked me to deal with, but as you can understand, in a general perspective, because of the time limits that I was imposed. So I don't want to keep in my afterlife life as a speaker, as most collective agreements do, and so I will. I would be very glad to go a bit deeper in the details of each and every issue that I have dealt with in our next discussion. Thank you.
Muchas gracias, profesora Rosario Palma Ramallo. Muchas gracias a todos los que nos están escuchando en YouTube y por Zoom. Tenemos unos 5 minutos para preguntas y respuestas, mientras el público se prepara para dejarnos quizá un par de consultas. Y yo puedo avanzar preguntándole, en su opinión, profesora Rosario, ¿qué importancia tuvo el diálogo social, aunque ya nos haya dado algunas luces respecto a esto, durante la implementación del programa de asistencia financiera en Portugal y posteriormente durante la recuperación de la crisis? Y pues quizá después de contestar a esta pregunta, entonces ya tiraríamos esta parte y pasaríamos a la parte siguiente. Muchas gracias.
Thank you for your question, Caterina. I would say that social dialogue has been important all along. As I said in my presentation, we have in Portugal a long tradition of social dialogue since the 80s of the last century, and it is regularly in that forum that the regulation is discussed. And so the solutions that are proposed there are in general adopted by the government and then go forward as a proposal for a new legislation. And as I said before, the adoption of the program, of the assistance program in 2011, this program was approved in May 2011, but there had been a tripartite agreement that had been signed by all members of the Social Consultation Council, except for one. And most measures regarding that were inscribed in the memorandum of understanding had been approved before. What happens is that the practical result of some of these measures were maybe not what was expected by the social partners. So the same partners that had signed that tripartite agreement afterwards, during the crisis and after those measures were implemented, didn't like those measures. And so revoking those measures was also a result of the next tripartite agreement once the crisis had been overcome. So it's always very important. I think it's a central issue, and it's always important.
Muchas gracias por su respuesta. Pues a todos los que nos escuchan por YouTube y en Zoom, profesora Rosario Palma producirá una nota técnica que será publicada por la OIT junto con los aportes de los otros expertos que también han participado y van a participar todavía en el ciclo de conversatorios. El próximo ciclo de conversatorios está previsto para el día 15 de junio y en este día escucharemos la experiencia de Alemania por la mano del profesor Dr. Gerhard Bosch. Y pues de momento agradezco a todos, pido a los que están conectados en Zoom que queden conectados. Nos despedimos del canal YouTube y pasaremos ahora a la reunión técnica por Zoom. Muchísimas gracias a todos y buenos días.